was in the right direction that the objection was dismissed. And in terms of the substantive arguments, I think arguments were preferred for both sides of the divide.
I mean, the conversation this morning is really to seek clarity on the matter, you know, and understand what a mandamus is, so everything that is going on. Now, the National Democratic Congress raised preliminary objections, right? And they were challenging the High Court's jurisdiction over these matters. So on what legal basis can such jurisdictional challenges be made? And what are the typical considerations for the court in such a situation?
The argument was that basically, once an election has been concluded, and this was the argument that was preferred by the NDC candidates in this particular matter, that once an election was concluded and there has been some declaration of some sort, regardless of the circumstances leading to that particular declaration, the only recourse for anyone who is affected by that, for want of a better phrase, purported declaration will be you seek redress by recourse to PNDC Law 284, which is the Representation of the People's law, where you can challenge the validity of an election, a parliamentary election, by way of an election petition. So basically, that was their argument, that to the extent that there had been some announcement, I would choose to call it, because we need to get this right. That
I like your choice of word. You said announcement and not a declaration.
Yes, because the declaration is a legal phrase, and you just don't arrive at a declaration. If you look at the Public Election Regulation CI 127, there are a number of processes that you have to go through before you get to that point where a declaration is made, and then the subsequent gazetting and all those kinds of things.
Right.
First and foremost, if you look at Regulation 43 of CI 127, you would note that at the end of the parliamentary elections in all constituencies, the polling station results for all polling stations, or the election results for all polling stations in that particular constituency, have to be assembled and given to the returning officer of that particular constituency. And then that is when the collation process is done. So all the polling station results are then tabulated or are then collated. And collation is simply addition. It is not rocket science. It is not something that is so extraordinary that has led us to all this. It's a question of adding the individual polling station results for all the polling stations in a particular constituency. So if the constituency has 200 polling stations, what it means is that you'd have to record all the 200 polling station results onto the Form 1C, that is the Parliamentary Election Results Collation Form. So once you put all the results, all the 200 results from the 200 polling stations on the Parliamentary Election Results Collation Form, the Form 1C, then you add it and arrive at the conclusion in terms of the candidates and what results that they got in terms of the number of votes they got and that. Then that is then transmitted onto the Parliamentary Election Results Summary Sheet, that's Form 1D. And it is on the basis of that. So it starts from the collation form, where you have all the polling stations listed with the polling station codes and the results attained by all the candidates in all the polling stations. Then once you get the number that each candidate gets, then that number is then transferred onto the Form 1D, that's the Parliamentary Election Results Summary Sheet. And it's on that basis then that a declaration properly so-called can be made. So holding someone's hand and announcing that this person has gotten X number of votes in the constituency without going through that process, without there being any evidence of the collation being done or completed, does not amount to a declaration in law. That's my respectful opinion. And so that's the crux of the matter. So as your reporter was saying that the NDC's argument was that to the extent that some declarations had been made, the recourse is to go by election petition. Unfortunately, that is not the understanding of the law in my opinion because of the processes that you have to go through by way of CI 127. And when the argument is made that this is an election petition disguised as a mandamus application, if you look at the PNDC Law 284, which gives the basis for mounting an election petition, it talks about cancelling an election result and grounds for cancelling an election results and all that. The issue is not a question about cancelling election results. And this is where I think the media, including your station, sometimes get it wrong with the whole idea of recollation. There's no issue of recollation. Collation was truncated in these constituencies because of the scenes which you reported it, all other media stations reported. Saw what happened in the collation center. So collation was truncated, and the police advised the Electoral Commission, because of the security situation, because some unknown thugs and unknown persons had more or less invaded these collation centers, and there were all manner of things happening. The Electoral Commission was advised to halt the process because of the lack of the security situation being unstable and all that. And so subsequently, it was scheduled to be done again. The collation was to be continued, not a recollation.
Doc, just for clarity, so is that the appropriate strategy to deal with that? I mean, in the areas where collation, like you're explaining, was incomplete because you say it was truncated, what are the proper legal obligations of the EC in that regard? What should have been done?
Under those circumstances where it's a question of life and it's a question of destruction of property, and we've seen incidents where pink sheets were destroyed, people went there destroying material, even the Tama Police Regional Command, there were some skirmishes that happened there and all that. Under those circumstances, I mean, how do you go ahead when the various parties involved or some parties involved are trying to or don't want the process to go the way it's supposed to go by law? Remember, it's a legal process that is supposed to be completed. So if you're not able to do that and your security is not assured, it makes no sense to be there to purport to do anything, because there's nothing that can be done at that particular point in time where people are all around threatening or demanding that particular candidates be declared, whether or not the process is complete, and all those kinds of things. So it was the right call. And remember, it was the Ghana Police that advised, because the Ghana Police Service was primarily responsible for the security of the elections. And they advised the Electoral Commission to halt the process, to continue it subsequently at the Ghana Police Depot at Tesano. But even that, we saw that there was the same situation that happened there. Again, people invaded the place when they disrupted the process and all that. So it was halted again. So it was because of that truncation of the collation process, not recollation, because collation was not done in accordance with the set out rules in CI 127 in all these constituencies. That led to the NPP candidates demanding the EC to do its job by way of the demand letters, which is a prerequisite for the mandamus application.
And now both parties have presented various forms of evidence, letters, video recordings, and all that. Doc, if you were to make an educated guess, which way do you think the court to be leaning?
That's something, I can't preempt or I can't do this, but you're asking me anyway. So,
I just want to know what do you think that the possible outcomes of this petition would be?
From the publicly available material, from the videos that we've seen of these, what I choose to refer to as announcements, and from all we know, the fact that there weren't any parliamentary election results collation formed. In some of the constituencies, for instance, like in Okaikwe Central, there was the returning officer in purporting to announce, or what some choose to call a declaration, I say is an announcement, clearly indicates, and this video is publicly available, so everyone can access that, said that the results that he was announcing was out of 110, was from 110 polling stations, out 140 polling stations in Okaikwe Central and the additional one special voting center making 141, representing 78% of the total votes or election in the constituency. And I asked this question. In an election, parliamentary elections, unlike presidential elections, is first past the post. And first past the post simply means that you can win the election even with one vote. There's no requirement of winning by more than 50% and all those kinds of things, which we see at the national level. So if the returning officer is announcing that the results that he's announcing is from or is based on 110 polling stations out of 140 polling stations in the constituency, representing 78% of the total votes or the election results in the constituency, I'll leave you to make your own deduction from that, whether that can be a declaration properly so called, especially when there was no parliamentary election results collation form, which I explained earlier on that the law requires that the results from all the polling stations in the constituency must be recorded on that Form 1C, and then that should be then transcribed or you take that and put it on the Form 1D, and on that basis, a legal declaration can be made as opposed to an announcement of purported results in a constituency.
Right. Interesting thoughts there. When you look at the machinations we use or we adopt in terms of election disputes resolution, I mean, to the extent that the Constitution allows, and how it has evolved over the years, would you say there are some gaps that we should be looking at filling so far to make the processes easier? What are those gaps?
Definitely. This election has taught us something. And if the arguments that some of the parties are making is anything to go by, what it will mean is that in future elections, if nothing is done, if we don't go through some reform process where we try to close some of these gaps, what it will mean is that immediately the election is over, all you have to do is find an EC official. It doesn't even matter who that EC official is, because in one of the situations, like in Tema Central, apparently it wasn't the returning officer from the constituency that announced those results. It was a different person from a different constituency. All you would need to do is find some EC official, and then maybe by way of threats or whatever it is that you can do, force that person, quote unquote, to announce results not based on all the polling stations in the. You don't even have to wait for the election results. All you have to do is hold the person's hand and say, I hereby declare that so and so is the elected, and then that will be it. That is a dangerous precedent, and it's a danger and a threat to our democracy if that particular position is allowed to stand. I don't think that's the intendment of the law. That's what anybody wants to happen. But there are clear processes that has to be done. But I believe that this whole idea of political party activists thronging to collation centers and threatening, singing all types of songs and all those kinds of things, it's something that shouldn't be part and parcel of our elections, because like I've said on other platforms, the collation process is the easiest part of the entire election, because it's a question of adding numbers from polling stations. It doesn't take anything to do that. And everyone who contested in these elections who knows the results, that's the belief, because the elections are conducted at the polling stations. The results are announced at every polling station. Copies are supposed to be pasted at the polling stations. The political parties are given copies of the pink sheets from the polling stations. And it's on the basis of these pink sheets from the polling station, the statement of poll, that you add them together, you assemble them and put the results on the parliamentary election results collation form. When that is done, then you know you have the full complement of the election results in that constituency. And on that basis, a declaration can be made as opposed to an announcement of the results, not based on anything. In the Tema Central constituency, for instance, apparently, and this could be independently verified, it's even on the videos, the returning officer that was purportedly announcing the results was holding an A4 sheet where the result had been written on, where They are clear. You understand what I mean, right?
Yeah.
That's not what our elections are
Right.
about, unfortunately.
Okay. So, I mean, the Constitution is clear enough, or the regulations that guide our electoral processes are clear enough, would you say? In terms of what to do, at what point, conflict resolution, they're clear enough. We don't need any review in that regard.
That's what I'm saying, that this election has taught us that people can do all sorts of things to truncate the process, which is supposed to be easy and all that. So maybe we ought to take the security situation much more seriously, and there have to be clear guidelines in terms of who can come to the collation center and all those kinds of things. Because
in fact, that is where most of the conflict erupted from. I was at Ablekuma Central also, and where Eslowusu lost her seat, Ablekuma West. And everything was peaceful until we started moving to the collation centers. And the security personnel said only certain people with accreditation can enter. At some point, those who even had accreditation were refused to enter the premises. And that's where the conflict started from. But let's move on. Let's get to legal recourse. Now, if either party is dissatisfied with the court's judgment, what legal avenues are available for appeal or further action? I mean, we await Saturday's verdict,
Let's not preempt anything. I mean, but speaking generally, where decisions do not go in your favor, depending on the context or depending on the type of case or the decision, there are certain avenues that are available to you. Obviously, an appeal will lie. We know that you can appeal the decisions of the High Court to the Court of Appeal, and there's a subsequent. You may subsequently appeal to the Supreme Court.
I guess I'm asking because I'm wondering what the typical timeline for such processes are, because inauguration is fast approaching.
Yes,
Parliament,
The point is that with these elections, for election-related matters, the court or the judiciary and the Chief Justice as the head of the judiciary has given a special warrant to the High Court, the judges of the High Court, or this particular judge, to deal with all election matters expeditiously. So you'll notice that in the Supreme Court case that came on, I think last week, Friday, thereabout, the court even talked about the timelines. It said that the timelines ought to be abridged. So it gave the NDC 2 days to file. Once they joined them in the mandamus applications before the High Court, gave them 2 days to file their affidavit in opposition, and then gave the NPP as well as the Electoral Commission a day to file supplementary affidavits, if any, and then prescribed or stated that Tuesday will be, which was yesterday, the day before, Tuesday 30th, I believe, 30th, or was it 31st or so, will be the day that the parties would go to the court to argue out the mandamus application, and then we saw what happened during that process. So for election-related issues, parliamentary election disputes, the timelines have been abridged. So definitely there will be some finality one way or the other, even though I foresee that some of these things may go beyond even the inauguration.
Lastly, before you go, given the high public interest in these cases, and I just want to refer back to that Afrobarometer report that said Ghanaians have lost trust in some institutions. The judiciary was part of the list that came out. I think the onus falls on the judiciary to maintain public confidence in its impartiality. How can they achieve that?
That's what's being done by giving everyone a fair hearing, by people being able to access the courts when they feel like they're dissatisfied with the process or with something that had been done or not being done. And that was the whole idea of the whole mandamus application, the fact that the EC wasn't able to do its work. And so the parties involved were demanding that the EC as a public entity do its public duty, that is to collate the results and declare the election results in these constituencies. And the police, being the law enforcement agency, provide security for that collation process to be completed. And so to the extent that the courts are open, accessible, yesterday, New Year's Day, the court was sitting.
Yes.
New Year's Day, it's a holiday, but the courts were sitting, and it's been adjourned for ruling on Saturday, which ordinarily will be a holiday, but the courts are working. So those steps are steps in the right direction that would ensure that there's fairness, there's clarity, and there's finality in all these issues. Thank
you so much, Dr. Kweku Agyemang-Budu, for joining us and putting this issue in perspective. He is the Dean, Gimpa Law School. Thank you so much. And that's that for this belt of conversation. We'll take a quick break, and when we return, we'll bring you a conversation on the expectations of the incoming administration. Like we did yesterday, we're looking at the 2025 outlook, and today we are focusing on education. I'll introduce my guests when we return. Please stay.